very much. Let me apologize for what is happening or what had happened in terms of the times. Our meetings are usually starting at 9 o'clock. I didn't notice the invitation. I took for granted that it starts at 9 o'clock. What is worse, honorable members and officials, is that the link, as you have heard from the message, that Lindiwe is not in today. She's writing the exams, and she discovered that the account has been closed whilst she has already sent the link. Now, what happened is that we have to resend the link. We apologize for that. It's worse now when I discovered that the other gadget is doing the other thing and I have to open my cell phone. So I'm going to open up the tablet again, but I will try and make it a point that I don't disturb other honorable members and other people. I hope you have apologized it. We'll next time look at it, and I will be very cautious in terms of time, because that's the confusion that has been happening. People were logging in at 9 o'clock to find out that the meeting has been set for 9:30, worst part of it for the link. I sincerely apologize, and the manager sent a message. In fact, he called me apologizing for what has happened. I hope, honorable members, you have apologized for us on that issue. Honorable members, are you still around?
Yes,
Yes,
Chairperson.
Okay, thank you very much. Then let's check Kilega, who is the stand-in for Lindiwe, whether is she able to flight the agenda so as to continue the meeting. Otherwise, everybody in the meeting here is welcomed, and we're going to make sure that we finish the meeting even before that one, because we know that honorable members and other people will have to drive at 12:30 to the chamber, and also others will be getting into the bus.
Good morning, Chairperson.
Morning.
Chairperson, I've logged into my tablet now. It doesn't show my name. So because I couldn't log in at all, so I had to go with the password. So just remember, if you see someone without a name, it's me. Thank you.
Oh, okay. Thank you very much. Can we request Kilega to tell us who is not in the meeting and who is in the meeting, and also tell us about the apologies?
Thank you. I have not received apologies since I'm standing in. I was just notified about it this morning. So Chair, let me go through the list of the members that I was given. Miss Abrahams, Miss Van der Merwe, and then Chair, Mr. Stondile Songo, Ms. Jane Mandanye, Mr. Drangstock is present. I have not seen Miss Bilangulu. Eli, can you please assist me? Mr. Stock is in the meeting, Chair. I have not. Sorry, Chair.
She's not yet in the meeting, sis. I'm gonna call her now.
Oh, okay.
And then apologies from Honorable Sukers Mari. Thank you.
Oh, okay, wonderful. Thank you. That's it, Chair. Over to you.
Thank you for that. But I noticed that Honorable Stock, at first, he was in the meeting. He has logged on, but maybe he's just experiencing some glitches. Well, let's maybe check for him, and then I can see if he's not in the meeting, he will definitely send an apology.
He is.
Thank you very much for that. From the
Jim,
our
remember, I'm also here. She didn't mention my name. Marie, Honorable Marie is also
Marie,
in the meeting.
Honorable Marie is in the meeting. She apologized for the name for unnamed gadget. She reported that. Thank you very much, Marie. And then we've got guests.
Chairperson,
amongst us.
Chair, this
Yes, I'm listening.
Bridget, I'm here as well. I didn't hear my name mentioned. Thanks.
Who's that? Bridget?
It's Bridget Masango.
Yes, yes. Bridget is present. Thank you. I've seen you when I looked at the people who's present. Thank you, Honorable Bridget. Can we then proceed the guests that we are having them in the meeting? Who are those?
Sorry, Chairperson, I'm also present, Liesel van der Merwe.
Okay, Liesel van der Merwe is also present in the meeting. Thank you very much, Liesel. So it means that we are cooperating in the meeting. Can we then get the guests?
Good morning, Chairperson, and good morning to the members. My name is Charmaine van der Merwe. I'm with the Parliamentary Legal Services Office, and I'm here to brief the committee on the process for a committee bill. Thank you.
Thank you very much. Van der Merwe.
Sorry, Chair, did you mention me?
Aris?
Yes. Did you mention me?
No,
Because I
no,
didn't hear
you
that.
were not mentioned. No.
I was in the meeting the whole time.
Okay, thank you very
Okay.
much for informing us, Honorable Aris. Then, who was talking behind Aris? Can we give him a chance? And okay, it means there's no one.
Good morning, Chairperson. I'm Daksha Kassan, and I am here with Advocate Charmaine van der Merwe from the Legal Services Office.
Okay, thank you. You are Pegios?
I'm Daksha Kassan.
Okay, Kasim. Okay, I saw your name and Charmaine's name. Are you only the two that are present with us? Or is there anyone, the third one?
Chairperson, good morning, and good morning, honorable members and colleagues. I'm Dennis Bandi. I'm also in the meeting briefly, unit manager for the social cluster. Thank you.
Okay, you're welcome. Also, unit manager, Mr. Bande. I also saw your name when I was perusing who's present and who's not present. Thank you very much for that. Then let's just go straight to the agenda.
Chair, may I just mention a third member of my team is present. I'm not sure if he's not able to hear us or anything. His name is Njabula Ngwenya. He is also part of the drafting team. Him and Ms. Kassan are the two that will assist the committee on the actual development of the team. So if you see the name Njabula's iPhone, I think is what it's called. That is the third member of our team. Thank you.
Okay. Yeah.
I'm also
Njabula.
present, Chairperson.
Okay. Mamanga Anyi has been mentioned that she is also present. Thank you very much for that. Okay. Also, Medi, Medi Peterson has joined now. It's a new member. We have already welcomed her. I know that she's not new from the box. She has just joined us, and she's also a member of the portfolio committee. Thank you very much for those information. And then let's go straight to the agenda. The agenda today that we have, it's one item. It's the briefing by the legal services team on drafting the committee bill on the Children's Act Amendment Bill. And we have to consider that bill or that presentation today. Can I get an honorable member to adopt the agenda as it has been proposed?
I'm proposing for the adoption, Chair.
Thank you very much, Honorable Manganyi. The agenda has been proposed. Any seconder to the proposal?
I would like to second Honorable Manganyi. Chair, it's Bridget
Thank
Masango.
you very much, Honorable Bridget Masango. The agenda has been adopted and seconded by Honorable Masango. Can we then give over to the team?
Thank you,
Who's going to
Chairperson.
start?
I
Okay.
am going to start. I'm going to be the one presenting today. I just think that the committee secretary gave permission to Ms. Casson to share, but I'm the one presenting. If I may just ask for them to give me permission to share my screen so that I can flight my presentation. While I'm waiting for them to do that, let me perhaps start and just give an indication, where we are. Ah, there, I've got it. I can now share. Thank you very much. I am screen sharing, it says. Okay, so please excuse me if my head is like this. It's because my presentation is on a different screen than the camera. It's not that I am distracted. I'm just looking at a different screen. So we have, when we look at committee bills, and we have come to realize that support staff, members of parliament, all have a different idea about what a committee bill is and how it works. So we thought to go very basic. So if some members here have done this before, I do apologize for repeating, but it is quite important because somewhere down the line, we have found in more than one committee bill that someone said, but I didn't know that that is how it worked. And it can actually affect the process. So I'm going to start very basic. And I ask that you just bear with me in that regard. So when it comes to, we've set out a standard operating procedure to help members and support staff to understand how committee bills work. So what we need at the outset, and this is very similar to how it works in the executive, is that we need a policy. So the policy outlines what it is that this bill should achieve. What is our goal? In other words, if we say we have a problem with roads not being maintained, how are we going to solve it? That is our goal. We need to find a solution on maintaining roads. So that is what I mean with a goal. But your policy will then also go further, and it will say, what are the principles that apply to this goal? So if we want to say we need to maintain roads, we know that there must be someone that oversees it. We know that there must be workers who will be doing the actual work. We might look at technology and how that affects labor, etc., etc. So there's a massive number of questions that goes around the mischief, the solution, and how we can make the solution effective to address the mischief. So all of that goes into the policy. And the problem is that although your policy is not law, it is something that might pull other laws into play, because the statute book works together And it's a pity that our statute book has grown as big as it is, because it makes it very difficult to ascertain exactly just how something affects another piece of legislation. And that takes up a lot of time to go and make sure that when we say X year, we don't affect another bill negatively because we are now saying X year. So to develop the legislation, we need that policy document. That policy document is so important that I can tell members now that if that policy document is not well developed, if we're not 100% sure what it is that we need to fix, how we are going to fix it, what are the principles needed to fix it, what is the implementation challenges, what are the risks, if we don't know that, I can promise you your first draft is not going to be something that you can advertise, because there's going to be so many questions that still need to be answered. So the policy document, I really need to stress, is amazingly important to do a committee bill. I can perhaps just give you an example. When we did the National Credit Amendment Bill with the Portfolio Committee on Trade and Industry, the department simply said to the committee, we need a way to deal with debt collectors. And they proposed regulations, which we then said, no, but this is not a policy. You can't just have you can't just say there must be regulations. This is passing the buck. And it, in the end, took that committee about 2 years to arrive at a policy that could inform a bill, because we drafted the bill, but all the time, I think we went through about 7 or 8 drafts of that bill, because questions kept popping up, and we needed to say, but how is this going to work? Who is going to take responsibility, etc. Now, once we have this policy, and of course, in this case, you will either your policy will be developed by the researcher, your committee's researcher, your content advisor. The department will play a massive role in this as well. They will be implementing. They must say if this one that we are proposing as Parliament will work. They might also have the necessary research. They might have background material, etc., etc. So there's a number of role players in developing this policy. And of course, there could even be an external expert that is approached in this regard. I know of a number of committee bills where the committee actually asked an external expert to assist. So, like I said, the policy document will now identify the mischief. It will show the research. It will explain the solutions. It will say what is the most suitable and then how it will be implemented. So that is all about our policy document. Then when we look at the time needed, and this is very important, because when I come to the process, when we develop a committee bill, you will understand why this becomes very important. A committee bill is only introduced at the end of its development. So it is totally the other way around from any bill that you have ever received, or a private member's bill that you have ever received. Because a bill that is not introduced is not something that passes over to the next Parliament at the end of Parliament's session. It is something that lapses. It, in fact, doesn't even lapse. It just goes into the void. But I will say a bit more about that. So from a sample of 22 committee bills, we have found that a large number were developed within a year from receiving permission. 2 of these were very, very urgent. And the larger majority of those were bills that were actually submitted by the executive. So, for example, the Administrative Information, Access to Information Amendment Bill, that was drafted by the department, and the Portfolio Committee on Justice simply processed the bill as a committee bill as if they developed it, but it was actually already developed and done by the department. So what I'm trying to say by this is that either there must be urgency, or we need to have a completed bill in order for it to be done in a year. Then there's also some that took between 1 and 2 years to be developed. 3 took 2 years from permission. One of that is the National Credit Amendment Bill that I referred to. And then some took 5 years. But that one was developed outside of Parliament. It was through the Speakers Forum. And I think there were just too many voices to be able to arrive at a final product. But so generally, we're looking between 1 and 3 years to develop a committee bill that is ready for introduction. So, like I'm saying, is all the circumstances of a bill they're not all the same. So I am giving you stats. It doesn't mean that your bill will necessarily fall in the 1 year, the 2 year, the 3 year, or the 5 year bracket. Every bill has its own circumstances. And some of these also had, there was no permission initially. There was some development beforehand. And then only did the committee approach the House for permission. What we have found, and again, this is important because it affects the completion of your bill and being able to introduce before Parliament rises, is where a bill focuses on one topic or at most 2 topics, we can do it within a year or 2. And when I say we, I mean the committee, and as assisted by its own support staff, as assisted by legal services in the drafting of the bill. Because it's not just the support staff and the drafters that will be working. The committee will have to do advertising. There will have to be consideration of various options, maybe looking at experts, maybe doing impact assessments, and so on. But we have found that the narrower the focus of the bill, the easier it passes through Parliament. So also if you have a time constraint, it is very important that you look at the things that could be challenges, and those will be policy. So we need a clear policy direction. We need resources. So if there's research to be done, there is someone who can do that research. We need, if necessary, external experts to provide advice. Those doesn't necessarily have to be paid, by the way. I know with the Intellectual Property Laws Amendment Bill, the committee was able to secure, I think, 3 experts who did some volunteering and because they were passionate about the topic. But so policy and having the resources, those are very important matters. Now, finally, I can tell you about the legislative process. I've now told you what we need. I've told you what we have done so far. So how it will work is that the committee will have to adopt and table a memorandum. Now, what the committee will do in this memorandum is to set out what the particulars and objects of the bill are. So this means the committee needs a policy document already, because you can't do the memo. You can't say what the bill will deal with if you don't already know what your bill will deal with, which is informed by the policy document. So I've already repeated, I've said what the sources of a policy document is, so let me not repeat that again. Then the House will consider that memorandum, and the House may approve, the House may set conditions, the House may refuse. But generally, these requests are approved by the House. And then the committee starts with the development of a bill. Now, we've given you an indication, if all goes well, if there's really no issue on the bill, the policy is clear, we have the necessary resources, and mainly this is where a bill focuses on 1 or 2 topics only. In other words, it's a streamlined bill. It is something that we can deal with quickly. For the committee to go through the whole bill, it takes maybe an hour. And then you are looking at about 19 to 40 weeks, in other words, 4 to 8 months in your first House. And that is actually all that is really, really urgent. We need to get this bill through the first House so that we can introduce, because once we introduce, it means it can be revived in the 7th Parliament. So once the committee has now developed the bill, we've drafted it, the committee has consulted on it, has debated, deliberated, then we need to advise the JTM on classification, and the JTM will consider the bill and will make a decision on the legislative process. Very important here is whether the National House of Traditional and Khoisan Leaders is affected by the bill. And we will only know that once the bill has been drafted. And the importance here is because the act that manages that governs this referral to this House requires 2 months for them to give feedback, which adds to your legislative process, because you can't proceed until those 2 months are done and you have considered those comments. So once the bill is ready, JTM has given its classification, the committee will report on the bill to say, this is now where we're at. We've developed a bill. We are ready to advertise, and we are going to advertise. And then that is what the committee does. Advertises the intention to introduce that bill, and it calls for comments. That you must give at least 3 weeks. This is in terms of the rules for the public to comment. And the relevant department or departments and organs of state must be given sufficient opportunity to come and address the committee and speak to it. And of course, the reason for this is because the department will be implementing. So any organization that is required to be part of the implementation must be able to come and talk to the committee about that bill. Now, from here, this process is very similar to an executive bill. So you will consider the public submissions, you will deliberate on it, you will decide whether there should be any amendments. If there's anything new that is proposed and that you add, we might have to advertise again and call for comments again. And this is simply in terms of case law, interpreting the Constitution and the duty of Parliament to facilitate public involvement. Once the committee is satisfied with the bill, there's no new amendments, we've maybe done a few final edits, then that bill is now ready to be adopted and we can introduce. So then the committee adopts that final bill, adopts a report that speaks to the bill, and again, the JTE must be consulted, and there will be a final decision on the legislative process for the bill to follow. And this is, of course, mainly important in respect of the NCOP process, because 76 bills work through mandates, 75 through votes. At this point in time, if the National House of Traditional Leaders and Traditional Khoisan leaders have already been consulted, we don't have to do it again. It has been done. We've complied already. So don't worry that by the time everything is done, now we suddenly have to go back to that house. No, we'll do it in the beginning, and that is where the 2 months play a role. Our office will also certify the bill. That's really a very quick process if we were part of drafting the bill, because we would have already advised you if there were any constitutional challenges, if the bill is conflicting with specific legislation, that it's not amending, that there's serious problems coming. We would already have warned you about that. So it's normally just a very quick administrative task to certify the bill. And then the committee introduces the bill, and you do that by submitting a copy and the memorandum to the speaker, and then the bill can have its second reading and be referred to the second house. So it is quite a lengthy process, but you will have noted that the main thing is that the introduction is right at the end. Otherwise, it seems the same as executive. It's just that introduction is totally on the opposite side of the process. So there's other things that our office will also advise you on. There are sometimes pre-introduction consultations that are required. It could be through the Constitution. There's a couple of acts that have requirements for consultations. But of course, this can only be once we have a final draft. So that is also a bit of a challenge, that you need to have a final draft before you can do these consultations for introduction. But we will be advising the committee on that as the process develops, so that we try our very best for these not to delay the introduction of the bill. But like I say, please keep in mind, we can only do it when the bill is done, and it might then be that is adding to the process as well. The certification I've already spoken to. I'm not going to go into too much detail there. Like I've said, if we have drafted, we will have alerted you to all of these issues. So I wanted to quickly show you the difference between an executive bill and a committee bill. You'll see that it both starts with policy development. And I've spoken about that. An executive bill, of course, doesn't need permission from the House. They need permission from Cabinet. Then we develop the bill. Now, this is done at the same time in both situations. There's a publication by the executive, there's a publication on the committee bill. But the big difference then is, once this is done, if the executive is happy with the bill, they can introduce. That doesn't happen in the committee bill. So with the committee bill, your process then still has to go in respect of public consultation process, deliberations, further amendments if necessary, etc. So in other words, the committee process that would happen on a department. So the clause by clause voting, etc. And then the committee bill is introduced. Whereas with the executive bill, it will simply be adopted and go for a second reading. Your committee bill is only introduced at this stage. Then it's transferred to the second house, and now you will see the process is exactly the same. In the second house, whether it's a committee bill, private members bill, executive bill, the process is exactly the same. So I've now spoken to you about the general principles on committee bills, the challenges. We need the resources, we need a policy, and you need to keep in mind that there might be aspects during the process that starts lengthening that development of the bill, simply in order to ensure compliance. Now, the one thing that we need to keep in mind with this committee bill, the Children's Amendment Bill, I am aware that this committee has worked very hard on a Children's Amendment Bill, and that part of that bill is what we now want to put in a committee bill. Please, members, you must remember that whatever you did in the previous process is no longer applicable. We can look at the submissions. In fact, we must look at the submissions that were made on those clauses that were separated and not proceeded on. But we will have to advertise again. We will have to go through deliberations again. So it is a whole new process. We cannot simply say, oh, but something was done. No, we need to make sure that we comply with the Constitution, comply with the rules in respect of this bill, and everything has to start from. Then time constraints. So I've explained to you the process, and that if we have a short period of time, our office would really recommend that we limit what the bill focuses on. So what we have already is we have about 126 clauses, which is the ECD clauses that which is going to education, and your foster care clauses that have been removed. However, apologies, there's about 126 clauses, and it's only those that have been done. It's now an act. The ECD clauses, the foster care clauses have been removed. There remains 126 clauses to be put into this bill. That is quite extensive. And I must be honest with you, in my estimation, that is going to take you 3 to 4 years to introduce. But everything is never say never. I believe firmly in never saying never, but I also need to caution members. I don't want you to do work and then it fizzles out because we don't have enough time. So there's not a lot of time, and we might go into July if elections are a little bit later, because it can be, but there's not a lot of time left between now and Parliament rising. And like I said, the introduction is the very, very last step. If that bill is not introduced, it goes into your legacy report, and that is all. It goes nowhere else. If the committee from the 7th Parliament does not have the appetite to proceed with this bill, it falls flat. We have had that on another committee bill where the committee has worked very hard on a committee bill. The department decided that, in fact, no, we need to pause, we need a bigger review. And so far, even though they've approached the chairperson, it does not seem to me that there's appetite in this Parliament. And then nothing happens to that bill. That is it. It's all that hard work is gone. The other thing also to keep in mind is that if you reach the point where you maybe have to do one more call for comments because there was one clause that we need to further amend, and that is at the time that Parliament rises, the new committee, if they have the appetite to go ahead with this bill, starts right from the beginning. They can use the final draft, yes, but they'll have to advertise the whole bill. They'll have to consider all the submissions that come in on the whole bill, and they may be making amendments to all the clauses that have been there, because for them, it will be a new process. They will have to ask the House for permission to do a committee bill, and then they will have to proceed from there again, from scratch. So I hope that you can understand why I'm saying it's so important that we introduce in this Parliament. And we need to consider all the challenges and make sure that we remove all the challenges and make sure that we can actually introduce in this parliament. So in the end, however, we are here to help you do this. We are very passionate about legislation. We want to make sure that what you want in that bill is there, and it is your decision. If you want all 126 clauses, then we put it in for you. But please, you need to keep in mind that it does lengthen the period of time. It lengthens the period of time that we need to draft the bill. Normally for a first draft, we ask 3 months to draft. There is a risk that you may then not be able to introduce that bill. So we would recommend that the committee chooses 1 or 2 themes, and that goes into the committee bill. The rest, then through oversight, can go back to the executive to say, please put that in an executive bill and bring that then in the new parliament. Specifically also in respect of content and support, some of the clauses in the executive bill had a lot of comment and debate, and we cannot simply take the bill as was introduced and take out the clauses that have been passed, take out the ECD, take out the foster care, and then we just use that bill and proceed. We can't do that. We need to look at the submissions that were made, because if we just use the bill as is, we are going to get the same comments. The public's going to say, but we have said this to you before. Why haven't you taken this into consideration? And we'll then have to take it into consideration. And we may then have to, again, make significant amendments and call for comments again. And that just adds to the time. So we would really recommend that we rather use the 3 months to draft to make sure that we've got a bill that already incorporates those comments, so that when we advertise, there is a lesser likelihood of having to advertise and call for comments again, because that just adds to our time. So even on the executive bill, there have been various redrafting proposals, new definitions, and so on. So these we need to make sure that those are in fact reflected. We do understand that there's a meeting next week and that you will be advised on all these clauses. And we would really recommend that your content advisor advises you then on those clauses and the issues that attracted a lot of comment, so that you can make a decision on which are the contentious ones, and perhaps those should go back to the department to bring us an executive bill so that your bill can flow faster. The committee will also, before we can start drafting, once you've decided on the themes that must go in, you need to deliberate and you need to decide, you need to come to the final conclusion, because we need the policy that must inform the bill. So if there was inputs made on a specific set or a specific theme, then the committee needs to decide, yes, we like this comment, no, we don't want to go with that comment. We decide this is how it's going to work. We need those decisions before we can start drafting. So the department as well is extremely important. The department developed initially the policy, and therefore they must advise the committee. Why was this policy there in the first place? So that the committee can make an informed decision when it instructs the drafter on what to put in the bill. So they need to explain to the committee what was the mischief, what was the policy, what were the views, and how would that theme or the proposed solution actually address the mischief. So furthermore, when we look at the policy the inputs from the public, there may be further requirements for policy development. And again, the department will play a massive role here, because like I said, they will be the implementers. It doesn't help we come up with some utopia solution, and the department says, but this is going to be so costly to implement that it is absolutely impractical. They need to be with the committee all along the way. They need to advise continuously. They need to indicate what is practical, what is not practical, so that the committee can make informed decisions. Like I've already said, again, we need that clear direction from the committee. So everything that has been discussed, once you've decided what you want to focus on, even if it is everything, but then we need to know what is the direction the committee wants to go on that theme. What do you want the solution to look like in respect of each mischief, each theme's mischief? So the proposed steps that we have on this bill specifically is that first off, like will happen next week, the content advisor will present on the clauses that will be considered for the committee bill, and that the content advisor then brief the committee also on the comments received from the public on those clauses. And thereafter, that the department briefed the committee on those clauses, the comments received, and what their views are and what they think each clause should read. Then the committee should consider all of these, and we would recommend the committee then decide, firstly, one, if we have, say, 8 themes, the committee takes theme 1 and says, yes, we want this in the committee bill. Theme 2, no, this is very contentious. There isn't a final solution yet. We refer this back to the department, and so on in respect of each theme. Then the themes that the committee has decided must be in the bill. The committee then goes back to those themes and say, okay, so we said we want this theme in the bill. What is the solution that we want? How do we want it to read? Who is responsible? How will this work? And we do that in respect of each theme that will be in the bill. Once that is done, the committee then goes and asks for permission from the House to develop a bill, because now we can do the report. We can say to the House, this is what we want in the bill. This is how things will work. This will be the financial implications, etc., etc. And at the same time, our office will then start with the development of a bill. Once we have then done the bill and the committee is satisfied that these themes and the solutions are correctly reflected, the committee can then do a call for comments. And in this respect, your committee support staff will assist you in respect of that call for comments. And I've already said that we need to make sure that it is worded correctly, because if we just take the bill as introduced before, we might have a problem with getting the same comments over and over and over again. Our office will at that point in time advise also the JTM on the classification, whether the bill needs to be referred to the National House of Traditional and Khoisan Leaders, and the committee support will assist the committee to report to the House. Then once we have all the comments, the deliberations, amendments, further consultations, etc. will happen. So we might have further amendments, we might have further calls for comments. All of this will happen until we reach a product that the committee is satisfied can be introduced. Once we have that, the committee then adopts a report. Again, your support staff will assist you with that. Again, the JTM needs to be consulted. Our office will assist you with that. And the findings of the JTM is then also tabled with the bill when it is introduced. Our office will also assist you with the certification of the bill. And then you introduce your bill and you can pat yourself on the back for a job well done. The bill will then have a second reading and will be referred to the second House. So members, that was a mouthful, but I do hope that it gave you some clarity on how a committee bill works. The challenges, things that you might not have known. And of course, I'm open to any questions if anything wasn't clear. Thank you very much.
Thank you, Charmaine. It's a little bit tricky, but at least it is clear once after we have received the presentation. Honorable members, let me pose it to you. Honorable Aris, Honorable Abrams, Honorable Lizelle, and then Honorable Stock, in that sequence.
Yeah, thank you very
Your
much.
Chair, I can't raise my hand. It's so difficult. I don't know why. Sorry for that.
Okay, you'll follow after Honorable Stock, excuse me.
I thank you very much, Chair. Thank you, Charmaine, for the presentation. Chair, while Charmaine was presenting it, just go through my mind that why was we not informed in the first place about this implications that the way we did do the bill have? Because remember that there's also financial implications if we have to go back through the process it means it will have a lot of financial implications. It also means that, as you have indicated, the time frame, it would be impossible for the committee, bear in mind that we are nearly at the end of our term, that it's an impossible task for us to push through with this bill. However, there are important pieces of legislation that need to be in that bill, because fathers and mothers' rights has been infringed even in this bill, children's rights also. So I feel that the legal people that have advised us right in the beginning should have be mindful. They were not mindful of what the implications of, the advice they was giving us was. Thank you, Chair.
Thank you, Honorable Aris, Honorable Lizelle van der Merwe.
Thank you very much, Chairperson. Firstly, I want to start off by thanking Advocate van der Merwe for the presentation. I think even though she had highlighted in the beginning that it was sort of a back to basics presentation, it was very important, because I think we as a committee will have to go back to the drawing board, because of two issues. Firstly, she asked us what mischief is it that we want to remedy. And it can't be that we simply want to now, as she had mentioned, we can't just go in and take the 126 clauses that were not passed in the initial bill and try and work with those. I think as a committee, the reason why we felt we wanted to have a committee bill was because we had gone through a public participation process. The public came out in their numbers, they had participated in this process, and in the end, we only passed the foster care clauses. And so we had felt that we didn't do justice to the process. And in particular, for example, we wanted to give effect to a number of voices that came forward in terms of, for example, fathers who were crying out that they want their fathers' rights also to be recognized. But now the question then becomes, so if we say, for example, the mischief that we want to remedy is one or two issues, and we then pick those one or two issues, the reality is that, as Honorable Aris has also outlined, we might not have enough time to finish this process. Because if we now say that we're going to pick one or two issues that are important to us, we want to put this in the committee bill, then as she had highlighted, maybe they will be done drafting by October, it will take 3 months. Then maybe if there is contentious issues, which I assume, if you're talking about the issues of fathers' rights, for example, then you will have to maybe go back to public hearings. You might have to open it up. It might even have to go through the other processes like she highlighted with the, traditional council and all of those things. So it looks like we might not be able to pursue this. I don't know, we'll obviously have to discuss it further, but I think the timeframes worry me. And so I wanted to ask Advocate van der Merwe, so say, for example, we do decide to take one or two issues and run with it as a committee bill, issues that we feel important, that have been left out. If we do not pass the bill in this term, I know it lapses. But I do know that in the past, when a new term of parliament comes in, there is an opportunity for bills that have lapsed to be reintroduced. So I just wanted to get clarity on whether that is indeed the case. So if we do the work and we run out of time and we do not pass it in this term of parliament, can it be revived in the next term of parliament? Thank you, Chair.
Thank you, Honorable Lizelle. Honorable Stock.
Thank you very much, Honorable Chairperson. Greetings to my colleagues and all the stakeholders, including the parliamentary legal advisors who are also part of the meeting. First and foremost, I think I would like also to agree with my colleagues who came before me to appreciate the presentation that was done by Advocate van der Merwe with regard to the processes, which regards to the legalities of the introduction and the processing of the committee bills in Parliament. So by so saying, I think the presentation of the advocate was quite comprehensive. It was quite elaborate because of it actually clarified a number of issues which were also hanging in some of our minds because of after we received the presentation, we also had an opportunity to go through it, and then we're asking ourselves whether we'll be able to pass this legislation given the time that is actually we are left with in Parliament. And now, taking from the presentation, one is even more worried that it looks like we will not have time on our side to be able to pass this. And then I'm also actually very worried because the advocate says to us, Advocate van der Merwe says, well, it's within your right as a committee if you want to start now with the process, but these are the risks involved. There's no time on your side. And then if we're going to proceed with the bill, to introduce it now, it will take almost like 3 months for the drafters. And then from there, we need to consider also the contentious issues from the draft bill before we introduce it. So it's a lengthy process, even before we will get an opportunity as a committee to introduce it. Now, and the other thing that worries me also very much, Chairperson, is that even if we say, let's start with it, let's introduce it now, then we proceed, we do the adverts, the drafting team, consider the contentious issues, introduce the bill. Say maybe for an example, for hypothetical reasons, and then we manage to introduce the bill on the time limit that is still remaining now. The problem is we'll not be able to finish it. So the seventh Parliament will then have to decide whether they are going to consider this or not. And if they reintroduce it, they have to go through the process that we have undergone as these members of the sixth Parliament. It means there must be an advert, there must be call for stakeholders, inputs, and all of those things. So the issue that Honorable Aris is raising of the cost implications, in this case for me, becomes a reality. That we are going to sit, consider this thing, spend money, and then leave it, close this Parliament, rise, without even finalizing it. And then the new members, when they come in the seventh Parliament, they will have to go through the process that we have undergone. So for me, it will actually be a duplication if you look at it in that context. So without necessarily saying, Honorable Chairperson, we don't want to do the work. We are always ready as members of the committee to do the work. And I think that has been the spirit of all members of the portfolio committee, irrespective of our political affiliation. We are ready to do the work, we want to do the work. But I think safe to say, I'm actually concerned about the time constraints that is actually not on our side. And also the risks that are involved. So I'll actually propose that maybe let's take note of the presentation that we have actually received from the Parliament Legal Services, and then we apply our mind as a portfolio committee as to what approach are we going to take. And then from the 126 clauses that are actually remaining, that we'll have to take through the committee bill, which ones are actually necessary in consultation with the department, because they are the implementers. We cannot just sit and say, no, we're going to take clause so and so, clause so and so, and the department feels, no, this one will not be implementable, and then advance their reasons. So I will actually propose that let's look at 126, let's take a decision as a portfolio committee, whether we proceed or we don't proceed. And then if we don't proceed, which approach are we going to take? So it's all up to us, honorable members, but I think, Honorable Chairperson, from my side, I think we don't have the luxury of time to pass this legislation. Thank you very much.
Thank you very much, Honorable Stock. That's why I started by yawning and saying, yeah, it's really a tough thing. I don't understand on how are we going to go through this. But let me also give over to Honorable Manganyi. There is this phone that is saying Samsung. Whether is it for Marie? Samsung.
Yes, Chairperson, it's me.
Okay, you will follow after Honorable Manganyi and follow Honorable Bridget.
Thank you, Chairperson.
And the last one will be Alex, Honorable Alexander.
Thank you very
Honorable
much.
Jane.
Thank you very much, Honorable Chairperson. I must also echo what my colleagues have said, thanking the Advocate van der Merwe. I thought it's Liz van der Merwe, yeah. Advocate van der Merwe.
It's her sister. It's her sister.
Oh, her sister.
Yes.
Okay.
And I'm not an advocate yet, maybe when I'm grown up.
by giving us this age. To me, is confusing my mind, but is a good advice. My question is that because we get into this issue while we were having also legal advisors. I just want to ask our advisors, when they were advising us, didn't seek the advice from them? Because why I'm asking is because of the state resources. We have crisscrossed the whole country, utilizing the state money, and then at the end of the day, we come not having anything in our hands. I'm just asking in future, or requesting that in future, because for now, we won't do any justice to this one. We will add more resources, wasteful resources. We will waste the resources by taking one thing or whatever, because this thing, you can't take a little bit, you can't chow a little bit from this. It means holistically you have to stick to everything, because this thing that make us to be where we are, we were told we are dealing with this thing only. And then we dwell on the thing. I so wish even the department are here, are listening. We deal with the only thing that they were saying, this is the agent one. Then we go there. We need not to hide. We need to correct where we did go wrong. Now we find ourselves today here. We couldn't do anything the whole, I can say for 3 years because of the COVID. We didn't do any justice to what we wanted to do. What we wanted to do, it was going to close that gap that we were told that here is that gap. So we were busy doing that. That's why we put what was in our heart. The Father for Justice, we said we are going to do this bill alone. We could have done that one only, because if we could have known that the step that we have started with is not giving us justice. So I think we have learned in a hard way, but I don't think we will start. Even although I'm not taking decision for the department, for the committee, I think it will be a tedious work to do. So the incoming, they will deal with it. Thank you, Chair.
Thanks, Honorable Mangani. I've said Honorable Marie, followed by Honorable Bridget and Alex.
Thank you so much, Chair. Chair, you know what is very disturbing when we listen to what is going on, because remember we had these meetings, we had a day by the hotel there in Cape Town, and we were discussing this thing, and we were saying to the committee, this thing is not right. And then the opposition party even walked out to say, but this thing is not right, you can't do this. And we were just put in a corner and saying, no, it must be like that. And now we are learning the hard way to say, but this thing is not right. The Fathers for Justice were complaining, sending messages, asking us what is happening. We actually told the committee, but we need to look at all these things, because this thing is going to come back to bite us. Now it has come back to bite us, Chair, and the opposition were mentioned as if we were the villains. But we were trying to do the right thing and to say, this thing is not right, this thing is not right. And the Fathers were very upset about them also being excluded about the whole thing. But I'm glad that we are coming back to rectify this thing, because what are we going to explain to the people? How are we going to explain to the people that this is what is going on? So I think let us learn from each other you know, even though we are different political organizations, we still have the same thing in common. We want to change things in our communities. So let us listen to the oppositions also, the smaller parties. We can also come with proper positions on how we can do things, not just to come up with one position and then everyone must just follow that position. But I'm glad the thing came back so that we can do a proper thing. Thank you so much, Chair.
Thank you, Honorable. Who's following?
It's me,
Honorable, yes,
Bridget.
Honorable Bridget, and followed by Honorable Abrams.
Thank you, Chair. And thank you so much for the presentation by the legal services. I just, Chairperson, am concerned that, I know it's been said, colleagues have said that it's late now, but I'm concerned that we had access to the legal services in the last time we were dealing with the bill, and the constant refrain that we were getting was that the bill will be done as a committee bill, and the work that we've done is not wasted, and so on and so forth. Now we know that the bill is, we have to start from scratch, and also we have to reduce the number of issues that we want to be part of the bill. My question is that why did we not get this advice the last time? Because it would have informed discussions that would have ensued in terms of wanting to know how we are going to deal with issues that were excluded in the bill that was passed, given the comments that were coming from the public and the very important issues, the important aspects of the bill that were left out to be dealt with in this process that we are discussing now. I just feel that we were promised, or we were sold fake goods in terms of saying, no, don't worry, this bill, the next bill of the committee will deal with this, the work is not lost, and so on and so forth. And now, another question is, if we take those few issues to make sure that we cover some ground in this term, can we then still go back to the rest of the bills of the bill and take other chunks as well? Or I just would like to know how we go back to the public that we went to say, don't worry, the bill will be tabled as a committee bill and it will be done by this committee, by this term, by this parliament, the 6th parliament. It is a very concerning thing, Chairperson, and it's very concerning, but thank you so much. I mean, this has been an eye-opening presentation that has sort of empowered one going forward, but it is hugely sad that we went and said, don't worry, guys, this is going to be done, and now we hear that it may not actually happen even. Thank you, Chair.
Thank you, Honorable Masango. Honorable Alex.
Yes, thank you, Chairperson. Good morning to the colleagues, and thank you to Advocate van der Merwe for the presentation. Chairperson, I know our secretary is not here today, but I think it's very important that whoever the acting secretary is for this meeting, the minute should really clearly capture what colleagues have been saying, and that we indeed do feel misled by the previous presentations we were given when it came to the timeframes and the certainty that we would have time for a committee bill, which is proving that in fact we won't have time. And I have a question to the Advocate van der Merwe. if we do look at our calendars, because your presentation didn't have actual months and clear timelines. So if we do look at our calendars, I think what we need to establish is that, is it possible? Because without those clear, months and timelines, we are just, assuming that it's not possible. And because, for example, if we say, okay, 3 months starting from when? Starting from June, that means the bill will be ready when we come back from constituency period. So maybe just, if you can give us some clear timelines so that we can actually make an informed decision about whether it is practical or not practical to continue. And, the concerns listed by colleagues in terms of cost, duplication, all of that is noted. But Chairperson, at the other side of this, this bill and this committee bill are the children and the vulnerable children of this country. And I just can't help but always, and it's what's presented before us, and it's the experience, is that children are not a priority for this parliament. They are always last on the priority list, and yet again, amending a Children's Act, they are again last. And next week we'll go through the clauses again. But also, to remind colleagues, we were talking about the National Child Protection Register. We were talking about children languishing in institutions, waiting for years to be adopted. And, other things that came through this process was abandoned children, abandoned babies, baby saver boxes. And, I encourage all our members to maybe set their Google alert to abandoned babies. And you'll actually be traumatized by the amount of Google alerts you get in this country, where children are just found, babies are just found in sanitary bins and rivers, etc., etc. So while we, have to be practical, there is a very real vulnerable child on the other end of this bill that we have an obligation and a duty to protect. And in my opinion, we are failing at that. So thank you, Chairperson. That is all.
Okay. We can't hear you, Chairperson.
I'm sorry, I haven't unmute. Thank you, Honorable Kate, and you are also welcome. At first, we couldn't see your name. Then can we ask you to raise what your point is? I see your hand is up, Honorable Bilangul.
Thank you, Chairperson. My apologies if you didn't see me, but when you started, it's only that I didn't start with you, but when you introduced, is it Medi or Medi?
Members.
I was there. When they adopt the second the agenda, I was there. But thank you very much.
Okay.
Chair.
Sure.
I also appreciate the presentation that we have just received from Advocate van der Merwe. But Chair, I'm a little bit confused because I don't think for now, as honorable members, we are on a blaming time where maybe one can point a finger to other member. Because as members of this committee, we were to be advised when it comes to the bill. There were legal teams that were assisting us while busy processing the bill. But the presentation we got today, it's like we still need time to go back and redo what we were doing. Again, there is an issue of time. What I wanted also to raise as a question is that, is it proper
or is it wise enough for us as this committee to proceed with this bill, bearing in mind that the time is no longer on our side? As the 6th Parliament, we are about to finish the term, and it's like the process that the bill will take, it's more than the times that it's now on our side, or the time that we are facing now before we go to the election in order to come back with the 7th Parliament. Is it proper for us to proceed or to go ahead with it? Or is it good for us and safe to put aside the bill and say the 7th Parliament will start? Because I don't know if I didn't get it clearly from Advocate van der Merwe that if we don't finish with it in this 6th Parliament, it means they are going to start afresh as the 7th Parliament with this bill, unless if I didn't pick it up. But for me, I just felt, Corey, it means we have been betrayed. If the legal advisors by then, they were indicating that we are on a right track. What we are doing is along the line. But if today we get this presentation to say what we did, we need to go back and do, to me, it's a lot of things. Bearing in mind the public purse that we will be spending, going to all these provinces, introducing, having public participation or public hearing, it's a lot of money. What is it that it's good for us, for this committee and the public for now to do, before we say we are going to engage on it as members, but knowing very well that the time constraint in front of us doesn't allow this process to be finished during this term. Thank you very much, Chair.
Okay. Thank you very much, Honorable Kate. Can I check whether is there any other person? No other honorable member. Can I get from Advocate whether what she is talking about is something that is new, which we haven't included to the session that dealt with the, what was it, in terms of that, don't go to Alina Bitun, the one from the can you come shake a look? Remember, we had to answer the court that gave us some time frames. Then we only dealt with that one, or with those clauses that wanted us to respond to the court. Now, when Advocate is saying we'll start new, in my thinking, I thought when she is saying we'll start afresh, it means that we are going to deal with new clauses that we haven't managed to deal with. Remember, we always said then we will continue with other clauses after we have dealt with the one that were requested by the court. Now, I just want to know about that before I say anything out of the comments that have been made by the other honorable members, because I'm also concerned that with the new clauses that we were supposed to deal with them, it's really late for us. I'm sure we have to pass that to the 7th term because we won't have time for it to. Remember, we still have to go for public hearings for older persons, and we have to go to really have some comments on it and public hearings on them. So Ndifuna Advocate to assist us on that. I hear her talking about 126 clauses, and when I think it's when we dealt with those ones that we're dealing with the High Court, And then when she means 120, when she mentions 126, she's talking about the new ones that we haven't dealt with at the first tranche. So can I get a clarification on that?
Thank you,
Advocate,
Chairperson.
over to you.
Thank you, Chairperson. I just want to make understand from you. I'm only answering the one question now, in relation to the clauses. So as I understand it, there was, and I actually just want to quickly check my bill numbers. Apologies about that. There was, yes, okay. So members dealt with Bill 18 of 2020, the Children's Amendment Bill. And that bill, what happened was that there was, oh, I'm sorry, maybe I'm not in the right. Yes, it is the right one. So Bill 18 of 2020, and there was a High Court order against the department that affected certain clauses on that bill. And as I understand it, the committee then separated the bill. Chair, I know you asked me to answer this one question, but I need to just say that I really don't feel well about the advice that you were given from another advisor, and I am going to report this to the Chief Legal Advisor, because there were another option that could have been given to you as well. You could have separated the bill, and you could have simply made a redraft of the one, and you could have proceeded on the other. And that was not given to you as an option at the time, and I don't know why. But so what the committee did was to reject the other clauses on that executive bill, Bill 18 of 2020. By rejecting those clauses, you have taken them off Parliament's radar totally. So they no longer exist in parliamentary speech. The bill then that went through spoke to a number of issues which then specifically also addressed that High Court order. That bill has been assented to. It is now Act number 17 of 2022. And it is, in other words, done. Parliament is done with those clauses. They are not coming back. The ones that were rejected by the committee in order to urgently proceed with the others, those are the 126 clauses that we were informed would now be part of the committee bill, and that you were that it was indicated to you that it can proceed as a committee bill. So just addressing that specific now, I would like an opportunity to address some of the other comments as well, but you've asked specifically just that question. So yes, the ones that were rejected will now be new. And because it is a committee bill, the fact that you have consulted on that before, it doesn't matter. You will have to start 100% new. You will have to decide on policy on those clauses. You have to have the bill developed on those clauses. You will have to advertise. You will have to consider those comments. You may need to make further amendments. You may have to further advertise, etc. It's a whole new process. And if this committee feels that it is necessary when doing public consultations to go through to the provinces, then that will happen again, will have to happen again on those clauses. We cannot rely on previous public hearings. Thank you, Chair. I hope that answered your question.
Okay. Advocate, just before that, you are saying the ones that we dealt with true because of the court order, we are done with those ones. The ones that we are talking about, or advocate, is the one that we were not, in fact, we didn't deal with them, meaning that it is as if then those ones will be, we will start afresh for them. That's how I just want to be clear so as to be able to lead the deliberations in the portfolio committee. Can you repeat that? Otherwise, I think I've managed to get what you are saying. And committee, it is really new things. That's why the advocate is saying we will start afresh. We are not going to have the continuity on them. Thank you. Can you
Chair.
just explain to that?
Chair, sorry. Chair,
But
I
my
have-
hand,
Aris,
my hand is up, Chair. You didn't notice me.
who's
Mine
that?
is-
Check it there on your chat. I have raised my hand.
Oh, okay.
Chair,
Aris,
yeah, thank you very much, Chair. Chair, this is very disturbing. This is really disgusting for this committee. Chair, you as the chairperson, and I did hear the lady was saying that she will report the legal services. It is your responsibility as the chairperson to also report the legal, because that's why the legal people are there. They are there because we are not legal people. We are members of this committee, and we are relying on advice that they are giving us. It can't be. We are in the month of May, and it is the month of the protection of the right of children. And we sit with the Children's Amendment Bill that we are now in a mess with. So please, Chair, we will hold you accountable as the chairperson of this committee to report this legal services. Thank you, Chair.
okay. Wait,
My-
wait so as to get the advocate clearly. Remember, Aris, why I'm asking this is that we have dealt with the one that had a court order. That's what I want to go at. And then now we said in the meeting, we will follow with other clauses. So does it mean that the advocate is referring to those ones, those clauses that we haven't dealt with by the time we were dealing with the other one? That's what I want to know clearly, so that if it is the case, we'll hear from the advocate, then we'll be able to conclude and summarize on what we are saying as the portfolio committee. Let's because in fact, what I've picked up is that we are separating those ones that we dealt with, which we are done with it, the one that we're dealing with the court order, and then these ones that we said we will deal with them later on. It's the one that the advocate. I just want to get that clear. Thank you very much, Aris. And then I see Lizelle's hand. Lizelle, you want to get in before the legal advisor explain this?
Yes, because Chairperson, I hear that Advocate van der Merwe is going to report the matter through her legal channels. But you see, there's another issue that arises now, and that is that when we were dealing with this bill, our main issue as a committee was, at that point, why we decided and resolved on a committee bill was because we wanted to do justice to the issues that were raised in the public hearings. Now, advocate says, because we rejected those clauses, rejected on the advice of the legal people that were advising us, they've now fallen off the parliamentary radar. So they've got no standing, which then calls into question, Chairperson, that the issue of resources, it means then we wasted resources for public hearings, for people to comment, for example, on issues such as baby savers, and for example, on adoption issues and fathers' rights. We wasted those resources because we now need to go back and start afresh. So I think really we need to be advised as a committee. She's going to report the matter, but we received bad legal advice, and therefore we rejected clauses. If we knew then that by rejecting those clauses, they will have no further legal standing and will have to start the process afresh, none of us, even you, Chairperson, would have agreed to reject those clauses. So I think we need to be informed about what is our recourse as a committee, because we received bad legal advice and therefore made a bad decision in rejecting those clauses. And the end effect of that is that we wasted Parliament's resources and even our own time as a committee. And I think therefore, I know we've ventilated these issues, but I think really we need to be advised of what is our recourse for acting as a committee on bad legal advice, also because we have wasted resources, wasted time, and now very possibly we will not be able to do justice to the very thing that we said we wanted to do. Marjane says now, if we knew that we will have to start afresh. We could have dealt with those one clauses or the one clause on father's rights. Similarly, then we could have dealt with the issues of baby savers, for example. So really, we need to be advised on what, as a committee, beyond this meeting today, what is our recourse in terms of going forward. Thank you, Chair.
Okay, let's give over to the advocate. Remember, honorable members, it's us, the portfolio committee, that said, let's start with the first phase of this bill in terms of considering for the court order, clauses, and then get into the second phase of other clauses for us to finish up the bill. So I want to get clearly from the advocate whether are we dealing or are we talking solely with these ones that we said it will be two phases. We'll separate the one that deals with the court order, and then second phase will deal with these ones that we haven't dealt with. Is it the case? So that before we do anything, reporting or not reporting, we must be clear of exactly what is it that is really a damage to this. Because when we go advocate, when we were doing public hearings, we dealt almost with all these clauses to the public. Then it's only us when we could pick it up that we won't make the due time, the time frames that were set by the court. And then we separated these clauses, dealt with the ones that we refer to the court order, and then said we'll deal with the second phase of the bill. Can we give over to the advocate?
Chairperson?
Yes.
My hand is up, Chairperson.
Oh, your hand
Before
is
the
up,
advocate
okay.
comes in. Yeah.
Let me see. Lizelle, is it the old hand, and Aris is the old hand? Honorable Stock.
Thank you very much, Honorable Chairperson. I think I'm sorry for doing this because I think it's actually necessary for me to come in before the advocate will come in and just clarify all of us, and then also be able to deal with all the issues that honorable members have raised. Honorable Chairperson, I think Honorable Bilankulu, when she spoke, I think she was assisting the meeting to say we must not actually spell, if I actually read well the input of Honorable Bilankulu, she was trying to advise the meeting and assist in terms of the way forward by saying that we must not actually, as members of the portfolio committee, we must desist and move away from this thing of trying to create an impression that there are certain members in the portfolio committee that have done a mistake, and also to a large extent try to shift the blame and start by pointing fingers. I think that's what Honorable Bilankulu was actually trying to assist the meeting. But now I want to come in and say, Honorable Chairperson, if you listen to the advocate or today's portfolio committee meeting, we're actually tabling, the advocate is giving us an advice in terms of the committee bill, which we actually rejected some of the 126 clauses that we did not consider when we were actually considering the clauses which were actually foster care related to meet the legal solution with regard to the North Gauteng High Court judgment. So why I'm saying this, honorable members, I just want to appeal to honorable members. Let's not create an impression as if there's a problem. The foster care related clauses, we received a better advice, everything was bad, and all of that. I want to caution honorable members, with all due respect, that we don't take such an approach, because the process in the portfolio committee was very clear. The advice that we have received, I don't see where I'm sitting. I cannot come to a conclusion now and say the advice that we have received from the other legal advisors was completely wrong, it was disgusting. I will not even go to the extent to try and name call the advice that we have received. You know why I will do that? Because of the advice that we have received, it has actually assisted us as a portfolio committee to be able to deal and meet the court deadline. And what we said in the portfolio committee then, which I think has not changed, we are still saying it even today. We said all the clauses that we have rejected as a portfolio committee, the 126 clauses, will actually consider those clauses in the form of a committee bill. Now today, Advocate van der Merwe presents to us, and we really appreciate, she was quite elaborate, like I indicated. These 126 clauses, with the time that is left for the 6th Parliament, this is the process, but we will not be able to consider all these clauses. I think that's what the advocate was saying. But I also want to, I want to appeal to the advocate, this thing that the advocate comes to our portfolio committee meeting and then also go to the extent of speaking bad about their own colleagues, it does not augur well with me as a member of the portfolio committee. If there are issues between those that came before us to come and give us an advice in the portfolio committee, and then Advocate van der Merwe comes now in the process of the committee bill and says, no, the advice that we have received before, it's actually wrong. This is what was supposed to have happened. I mean, the question that I will ask now as a member of the committee, I will ask, why did Advocate van der Merwe not clarify us and correct that advice when it was given to us? Why did she wait for the process of the consideration of the foster care related clauses to be concluded? And then when she comes now and when the portfolio committee starts with the process of the committee bill, then we are told the advice that we were given is wrong. I think the fair approach in this regard, Honorable Chairperson, which I will actually propose to the portfolio committee, is that now that we've got Advocate van der Merwe coming to us and saying, no, we have received wrong advice. The fair approach was going to be, we have a portfolio committee with all the legal advisors that has given us the advice from the start up until now, so that we can make an informed decision as members of the portfolio committee, and not to be told by a legal advisor who comes to the meeting, and then she says to us, no, you have received bad advice. Bad advice on the basis of what? And the fact that Advocate van der Merwe says she's going to report it to the chief legal advisor and all of that, it's a process that can actually unfold. We will not be able to stop it as a portfolio committee. But that seed of division must not be planted, and we are not saying anything about it. I think it's wrong for the advocate to say that, and I want to condemn it with the necessary contempt that it deserves. It's wrong for an advocate to come to a meeting and say, you have received the wrong advice. If there's a wrong advice that you have received, she was supposed to come with all those colleagues that gave us a wrong advice. We sit here, we listen to them, they present their side of the story, and then we apply our mind objectively as members of the portfolio committee. We don't want to be drawn into, if there are issues between legal advisors of parliament, we don't want to be drawn as members of the portfolio committee into such issues. We are here to do our work, and we want to do our work as constructively and positively as we can to assist the ordinary children on the ground. And I think clearly, quite clearly, Honorable Chairperson, let us not allow ourselves to be drawn into these reckless statements that are being made. Thank you very much. I think the approach is quite clear. The advocate presented to us. This is the process in terms of the 126 clauses. And I hear that there are honorable members who want to go to the extent and then cry over spilled milk, if I can use that word. The process of the consideration of the clauses which were foster care related, it was a process on its own. And then the committee went step by step, and then we considered the clauses, adopted them. And now we are on the process of the committee bill. And this is the process, this is the challenge that presents it to us. We don't have time on our side. What is it that we're going to do? Do we consider now, and then towards the end, we hand over the baton to the 7th Parliament? I think that's the challenge that presents us before the committee. Thank you very much, Honorable Chairperson. But in conclusion also, before I submit, I want to say, let us not play politics with the lives of ordinary people. Our responsibility as members of parliament, all of us, is to ensure that the rights of children are protected, the rights of fathers are protected, and all the stakeholders that have got interest in the bill, ordinary South Africans, we protect their rights and make sure that children in South Africa, to a large extent, are all protected. Thank you very much, Honorable Chairperson. Thanks.
Okay, thank you very much, Honorable Stock. You
Yes,
have
no problem.
partly
Ulile,
covered.
Yeah.
Yeah.
Bendithe nam ndikhona.
Honorable members, there are also
Yeah,
other
I've
hands. I
raised
don't
my
know
hand.
whether it's new,
I've raised my hand.
And then Alex, you've also raised your hand,
Yes, Chairperson.
the new one. Okay, let's give over
Yeah.
to Honorable Manganyi because she's unable to raise her hand in the
Okay.
gadget, and then followed by Honorable Aris, and followed by Honorable Abrahams. You know, I would like again to have an input after you have finished presenting yourselves. Over to you, Honorable Manganyi.
Thank you very much, Chair. I think most of us, we are speaking the same thing, even if it's a different language. The issue is that we dealt with the amendment that we were told that is due for at court. So we need to deal with it with immediate effect, of which we did. I didn't hear because my gadget also, it's not audible to my side. When I asked the advocate that, where was she? Because if she's working together with the legal advisor, that because we did have even the parliament legal advisors, if she could be around, she could have assisted. For now, that's why what I was saying to say, we can't go with so many things. It's too much for us to chew 126 something. So the matter, myself, I'm not buying the issue of supporting whoever, but the legal advisor were there for us. So I asked the advocate van der Merwe if she's the senior, where was she when we took, she was, if she got interest, she could have heard where do we come from. We're coming from a long, long way. And then I'm not blaming us all, because when you are in committee, you've got different view, but the majority view, it remains, is the one that is followed. In all this thing, we have worked together, whether fighting, when we are not fighting, we are not doing the job. The other have different view, the others this one, but I supported what Honorable Stock is saying. But I'm saying, even if we can take one, it's still late for us to can do. Maybe we should alone as the committee talk more about this thing and see where can we go. I like talking here because it raises my emotion because we have worked so hard. Thank you very much, Chair.
Honorable Aris.
Yes, thank you very much, Chairperson. I even take off my glasses now. Thank you very much, Chair. Chair, mine is just, the advocate did come here and give us advice. The advocate have informed us, because she's a legal person, she said that we were advised wrongly. And if we are questioning the advocate, it is our right to go back to our recordings and listen to what the advice that the legal was given us. And I feel we are, that right now, some of the members are busy to attack the advocate just because the advocate come and give us the truth. Or must we just hide the truth and say, no, the previous legal people were right, they was wrong. And that's why we're in this situation as we are. So all I'm asking, Chairperson, is that if the legal, because right now there's an attack on a legal person that is totally got nothing to do, that was not part of the process. All I'm asking then, let us get the recordings and then we can say, yes, the legal was wrong, or no, this advocate is wrong. Please, thank you.
Honorable Abrams.
Yes, thank you, Chairperson. And Chairperson, I wasn't going to raise my hand, But, listening to what I just heard, I felt that I had to. And, we all have our own freedom of speech. And thank you, Chairperson, for allowing all of us to speak freely in this committee meeting. But, we have to, as members, point out contradictions. So for a member to say we must not point blame at each other, to only then proceed to start pointing blame at legal advisors, is just not correct, Chairperson, and it's a contradiction and it must be pointed out. I mean, it's not right to point blame at the legal advisor who's currently on the platform and ask where she was, when we could very well be asking the questions, well, where are all the legal advisors throughout this process that was swapping and changing and swapping and changing? They gave us the advice. So where are they during this briefing, and where are they going to be at next week's meeting briefing? So there's clearly a lot of blame to go around. And also, Chairperson, pointing blame is, some people can view it as that, but also as a committee, we have a responsibility to point out the facts. And the facts are very clear in our minutes of what transpired through this process. And if the shoe fits for some members to now be defensive, then so be it, Chairperson. Then lastly, Chairperson, I just need to also now get clarity on the way forward for this committee meeting. And I did ask a question, and I don't think it's been answered yet. The question is will there or will there not be enough time to process a bill? And then also in this meeting, Chairperson, will we or will we not be making a decision on whether to move forward? Because my concern is, Chairperson, we are always pressed for time. We have a long constituency period, it's elections, it's all these other excuses. And then next week, we're going to come back, and on our program again is to discuss a children's amendment, a committee bill, which if we can make a resolution in this meeting, may or may not even take place. So therefore, we're wasting a whole nother week next week discussing a matter that can actually be resolved today, Chairperson. So clarity on the way forward from here, Chairperson.
Thank you very much, honorable members, by your inputs. Out of the discussion that I'm having, I definitely have, as a chairperson, to try and put the ruling on this. Let me remind you, honorable members, before even giving the last word to the advocate, that it's us who said we will separate the clauses that dealt, that was dealing with judgment, High Court, Johannesburg of High Court. Remember when we couldn't do the second phase, that is the 126 clauses, we asked whether the terminology that is being used, is it the rejected word or deferred? Because all other 126 clauses, we said we have to defer them to the next phase. And we were told that the right terminology that we should use is rather to say rejected, whilst we were going to deal with them on the next phase. I think what I would like us to do, let's not go backwards and forward. It is as if that we are being advised now that whilst we rejected those ones, it will be as if we are dealing with the new ones and we will start afresh. That's why I'm asking that question from the advocate, whether is it because she is dealing with these ones that we said rejected, minus the ones that we dealt with that one. I am asking that. And the last question that has been asked is that, do we think that we will be able to finish up these ones, that is 126, with the short time that we are left with up until elections? Or do we have to defer them to the seventh parliament, that is the next term? That's the question that is on the table. Before reporting or not reporting to wherever, But let's also, as committee members, ask ourselves, is it fair for us to deal with these ones as if we are dealing afresh with them? Or do we think we can refer? Let me say not refer, but let me say direct the 7th term of Parliament with this one. Are we able to start? Even if we're going to start with the 2 or 1 clause, do we think we will have the time to deal with that one whilst we are also faced with the older person? Or do we have to finish up this one that we have already started, knowing exactly that we have 126 clauses that we have to deal with? That's the question in front of us and let's ask the legal advisors to deal with whatever that they think they have to advise us separately from this meeting without reporting whoever and reporting whatever. And I'm not going to report anything because I know what we have said. But what we would have to get is the advice right now. Will we make it? Is it proper for us? And for next bill, even if we're not here, we have to know whether the terminology that we used of rejecting was correct, or we have to use another term to say we defer them to the next phase. That's what we want to get from the advice. Otherwise, you have tried to put it clearly, but let's not, I don't want to say blame one another, but I would like to say let's remind ourselves, and we cannot even go back to the recording all. We know what we have said, honorable members. Let's just remind ourselves and remember on what we have said out of dividing these phases. Phase 1 and also phase 2 will be the other clauses that we haven't dealt with. Advocate, you will be the last person, and then after that, we'll have to take a decision whether we refer. Let me put the terminology, refer to the next term.
Thank you, Chairperson, and thank you to the members. I just want to clarify, Chairperson, when I answered before, I only replied to your question. I was not replying to members' questions yet. And you saying I'm the last, so let me just quickly respond to all the questions that members have posed. Firstly, I want to confirm that, like I said, what was dealt with under Bill 18 of 2020, the issues that dealt with the court order, that is finalized. I'm not referring to any of those clauses. The clauses I'm referring to are the ones that were rejected and that will now either form part of a committee bill or not. So I just want to clarify one specific thing in respect of introduction, passing, and committee bill. With the committee bill, introduction is only at the end of this portfolio committee's process. And that is why I am concerned. Because if this committee does not finish the bill to the extent that it can introduce, then that bill cannot be revived in the 7th Parliament because it is not a bill yet. It only becomes a bill when introduced. So at best, this committee will be able to put that work done in its legacy report, and then that will have to go to the 7th Parliament, and that committee, if they decide to again do this committee bill, will afresh have to ask for permission, will have to consider the bill as it was done at that point in time, and they will have to again call for comments. So that is why I was saying that there is a risk. If the committee decides to include all 126 clauses, that is a real risk that the committee needs to keep in mind. Chairperson, a number of members asked about the approach, what can be done. Chairperson, I want to just make the committee aware that you don't have to blindly stare against a committee bill. The executive has worked on this bill. We have met with them. When we discussed the committee bill, we have started going through those 126 matters, and we have pointed out to them that we need to know what is contentious and not in order for us to be able to advise this committee. The executive is thus on top of those clauses. nothing stops this committee from saying to the executive, you need to go and do a bill now. You need to start now and start with that bill. Because remember, Parliament has the disadvantage of rising for elections. And then there is a period where there is not much happening at all after that rising, unless there's an emergency. Then there's elections, then there's new members, then there's new processes, there's new work coming in, etc., etc. All of those things are what counts against Parliament in respect of this bill going out in one form or another. The executive does not have those limitations. If they start on a bill now, they can continue next year, April. They can continue in May, in June, July, and they can introduce a bill that is updated, that has taken the public's comments into consideration, and that bill can then proceed. So it's not necessary to wait for the 7th Parliament to do a committee bill as well. It can go back to the executive to do the work and start already and draft and go through the legislative processes. It is not a one or the other. If the committee decides not to proceed with this committee bill in this Parliament, it can go back to the executive and they can start working on that. The other thing, the question was about whether you will make it or not. That's a very difficult question for me to give to you. We're in May. Parliament, if it rises, normally so far Parliament rose in April. I don't know when elections is going to be. We've got the new Electoral Amendment Act that brings in new ways of working when it comes to elections. So I don't know if elections will be in May or June, July or August. And that will depend on when Parliament rises. But if we look at April, it means that less than 3 months that you lose already in this year. You have maximum 8 or 9 months to do a bill. If you focus on one matter and you give this bill priority, you might be able to introduce. But you've also mentioned older persons that you need to deal with. I know that from the NAPC, Speaker has given some instructions about bills being given priority and being finalized. So there's that is also on the committee. Towards the end of the year, there's further budget processes that also interfere with legislative time. Chair, I really feel like a doomsday prophet, and I don't want to feel like this. But I would caution, I would say if the committee wants to do a committee bill, to choose one, the most important one of all of this. And then, lastly, Chair, I think that is all the questions that were answered or that were asked. And then, Chair, if you would allow me, I just wanted to make a note that I was not putting any blame on any legal advisor. I am disturbed by what members have been saying. And as a member of the office, Mr. Mjikizane does not report to me. But as a senior member of our office, I need to inform our chief legal advisor of what has transpired, and she may contact you to obtain further information. I don't know what happened. I do think there was other ways of that this could have been done easier, but I don't know what happened in your committee. But I cannot hear these comments from members and not do anything about it. Thank you, Chairperson.
Thank you, legal advisor. Honorable members, it's up to us then. I think we have to take a decision whether we take one, whether we refer this to the next committee, to the next term, or what do we do? We're looking at the time, whether the House is going to rise. It has been put forward that the House is going. Otherwise, I think I also have to take an advice from one of the members that is saying, let's go back. I don't think we are crying over spilt milk when we say let's go back, and the first item, even if we give ourselves 15 minutes before we start the new, because I'm worried that when we refer things to the next meeting, it also clashes with the, with the program and the agenda of the meeting. But we can maybe request Lindiwe to start the meeting on a usual time, or at 9 o'clock, as we are used to start our meetings at 9 o'clock, and then have that 30 minutes discussion. If we have to deal with this, we can even take 30 minutes, that is 8:30 meeting, and then deal with the other items that we were going to deal in the next meeting, rather than to do backward and forward and backward and forward and deal with this. In fact, it needs only 15 minutes to deal with it by saying, okay, let's take one, and then, okay, let's not even start by talking about this, because we have to go to older persons public hearings and rather focus on one thing. I think the advocate has given us the way forward in terms of that. I'll give only those people that will just say, okay, I second to that, because it was also raised by other members. Honorable Aris and Honorable Stock, you'll be the last one on this item, because you have put it clearly on what you think we must agree upon. Honorable Aris and Honorable Stock.
No, I think it's an old hand, that one, Chairperson.
Thank you very much, Aris, to inform me that it's an old hand, because you have put forward your suggestion. Honorable Stock.
Thank you very much, Honorable Chairperson. I just wanted to agree with your proposal that you are putting, that we must defer this item to finalize it in the next committee meeting. And then we start with it maybe for 15 minutes, like we've indicated, 30 minutes, and then we close it and then we move forward. Thank you very much. I move to propose and support your proposal. Thank you very much.
Thank you very much, Honorable Stock. Go back and consult. I know for a fact that you have to go and consult in terms of what I have proposed. I'm not going to repeat it, because I might miss other things, but I have been seconded. I didn't have any choice but to request the honorable members to go and think about this, whether we take it looking at the months that we are left with, or concentrate on the older person, because I think next week you have to start these public hearings in terms of this. And then what is it that we're going to do? To focus on that older one, or to focus on the new one, that is the older person's bill. Thank you very much, honorable members, and thank you very much, advocate. Let's inform the secretary. In fact, the person that is Kileka, who stands in for Lindiwe, must also brief Lindiwe about this, and Yuli and Godula, they are present with us. They must take forward this. And then, thank you very much, advocates and legal advisors. The meeting has adjourned for now. Thank you.
Recording stopped.